Welcome to the Guardianship training. In this training, you'll decide how to complete the guardianship process and if it's right for you. There are essential questions which will be determined during this training. What determines if guardianship is needed? What level of decision making best suits my situation? What type of guardianship fits my need? What resources are available to obtain guardianship? And what should be expected from the guardian? How to determine if guardianship is needed. The definition of guardianship is a person who looks after and is legally responsible for someone who is unable to manage their own affairs, especially an incompetent or disabled person or child whose parent has died. Five things you should know if you suspect that a family member is mentally incapacitated. There is no incapacity per se. Florida law presumes that you have capacity until a judge decides otherwise. Only a judge can declare someone incapacitated. A letter from a doctor, hospital, psychologist, or psychiatrist does not have any legal effort other than serving as evidence in the court case. Your familial status does not entitle you to make decisions for someone else. I am his wife, husband, son, or daughter, and I can make decisions or sign documents for him is not admissible in court. The only exception to this rule applies to parents of minor children. A durable power of attorney does not mean that you can prevent someone from acting inappropriately. A durable power of attorney can be revoked by the principal or the person who the consent is signed for. The travel agency doesn't have to ask you if the agent under the power of attorney says to close a deal. And finally, in the process of determination of incapacity, the court will appoint an attorney to represent the alleged incapacitated person. The purpose of the process of declaration of incapacity starts with the petition, but once this petition is filed, the court will appoint an attorney as well as three examining committee members who must visit the alleged incapacitated person in person and file their reports to the court. Some rights will be removed but cannot be delegated to others. For instance, the right to marry, the right to vote, the right to personally apply for government benefits, the right to have a driver's license, to travel, to seek or retain employment. Other rights will be removed and delegated to the guardian. The right to contract, sue, defend lawsuits, apply for government benefits, manage property, or to make any gift or disposition of property, to determine his or her residency, to consent to medical and mental health treatment, and to make right decisions about his or her social environment or other social aspects of their life. It should also be noticed that if you are hiring an attorney to represent you, you will need to understand that the court will appoint a separate attorney to represent the alleged incapacitated person. This is what due process is all about. Again, the five things you should know: there is no incapacity per se. Only a judge can determine incapacity. Your familial status does not count. Power of attorney may not be enough. And the alleged incapacitated person will get a separate attorney. What level of decision making best suits my situation? Let's take a look at this video.
As individuals with disabilities are nearing the age of 18, a lot of families think that they must get guardianship, in part because it's the only thing many of them have ever heard of, and also because they don't realize that there are other alternatives that can be available. But guardianship is more significant than most people realize. Now, don't get me wrong, there are times when guardianship is absolutely necessary, but there are also times when less restrictive alternatives may be appropriate. Most people think that guardianship is simply a way to stay involved, to get information, and to make decisions. But guardianship's a lot more involved than that. Guardianship is the process of having a person declared a protected person by the court. Only a court can do that. So when a person with a disability turns 18, they are an emancipated person just like everyone else, unless a court declares them a protected person and appoints a guardian for them. Now, in Indiana, we do have limited guardianship. So if finances are really your big concern, you can always become the guardian of the estate because that deals with financial matters. If healthcare is your big concern, you can become guardian of the person, which would cover medical matters or specifically even limit it just to medical matters. But most guardianship in Indiana is full or plenary guardianship. When a person is under full guardianship, they no longer have the legal right to make any decisions for themselves, except the right to vote, which cannot be taken away because they are under guardianship. We tend to focus on the guardian, but it's not about the guardian at all. It's really about that protected person status. So it's important to know that only a court can reverse that. Guardianship does not end because the guardian doesn't think it's needed. Guardianship doesn't end because the guardian doesn't want to do it anymore. And most importantly, guardianship does not end because the guardian dies. Now, you can have a co-guardian in place, and you can add a co-guardian later on, but you must go through the court to do that. But there are some other options though too, and one of them is supported decision making. Frankly, we all use supported decision making in our own lives. Supported decision making is the concept of going to people you know, people you trust, experts, to gather information to help you make a decision. As a concept, you can use supported decision making as a support structure. You can use it as an alternative to guardianship, or you can use it in conjunction with guardianship. Supported decision making is a great way to ensure self-determination. Research has shown that individuals who maintain self-determination, who continue to have decision making over their own lives, enjoy a better quality of life and a longer life. And frankly, you can start supported decision making at any time. The younger, the better. If you establish supported decision making as part of the decision making routine, you'll always sit down and discuss decisions. So as individuals are learning how to make decisions, it's a good way to teach them how to make decisions. What are the issues or the questions we need to consider? Who can they get information from? And how do they evaluate that information? And then as they've learned how to make decisions, it's still a good way to keep communication open and to talk things over. And frankly, you can use supported decision making over small things like what to eat and what to wear, as well as bigger things like what type of job do you want to have? What type of medical treatment do you need? Do you understand your health needs? Again, supported decision making can be used as an alternative to guardianship, but it can also be used in conjunction with guardianship so that even if a person is under guardianship, they still have some say in their own lives. Another option is power of attorney. Power of attorney is actually really common among seniors and among the military, so more places are familiar with power of attorney than they are adult guardianship. Power of attorney is where your loved one is giving you permission to act on their behalf. It allows the individual to continue to make decisions for themselves, but also whoever they designate as power of attorney to make decisions for them too. And it can be as general or as specific as you'd like. So your loved one can give you power of attorney with their cell phone provider, in which case you can call their cell phone provider. You can make decisions with their cell phone provider. But if you need to call their bank, you're out of luck because you don't have that permission. Or they can give you power of attorney over all financial matters, over all medical matters, over all government benefit matters. As I said, you can make it as general or as specific as you'd like and cover whatever topics you'd like. The other great thing is you do not have to go to court. You can draw up a power of attorney to cover the issues you want and have it notarized. If there's property involved and the power of attorney covers property or financial issues, you may want to record it with the county recorder's office. Every county is a little different, but you can talk with them about this. It's also easy to issue a new power of attorney. So if you have power of attorney with your loved one and you're getting to the point where you're not able to do it anymore, or you want to retire and move to Hawaii, your loved one can easily name someone else as their power of attorney, like a sibling or a cousin or a friend, as the new power of attorney. Another option is a healthcare representative. If healthcare is your main concern, your loved one can designate you as their healthcare representative while they're still competent. This allows a healthcare representative to make healthcare decisions when the time comes if the individual is not able to make them themselves. For example, if they were in a really bad car accident, if they developed Alzheimer's disease, or if they somehow lose the capacity to make decisions according to the doctor, the healthcare representative can then make decisions. In order to make the appropriate decisions, the healthcare representative needs to know what's going on. So often, if somebody is designated as the healthcare representative, medical professionals will share information with them, or it will prompt the medical office to provide HIPAA releases so that they can start speaking with the healthcare representative. Now, the state does have a specific healthcare representative form, but you don't have to use that form to be a healthcare representative. It just makes things a little easier. It can feel overwhelming to figure out how much support a person may need. Do they need a guardian? Would a healthcare representative work? What do we really need? The good news is that there are tools out there that can help. LifeCourseTools.com has something called Exploring Decision Making Supports. The ARC of the United States has a self determination scale. And Indiana Disability Rights has developed tools to help determine the support needs a person may have. All of these tools are available for free to help you and your loved one determine what is best for you and your family. For more information on this and other topics, visit the ARC of Indiana at arcind.org and the Indiana Family and Social Services Administration at in.gov/FSSA. For information on charting the life course and on how life course tools can help individuals and families develop a vision for a good life and identify how to find or develop supports, visit lifecoursetools.com. And please don't hesitate to contact a family advocate at the ARC of Indiana by calling 317-977-2375 or 800-382-9100.
Levels of decision making. Your child will be emancipated at 18. There are more ways to be involved just than to declare your child incompetent. There are supported decision making options, such as power of attorney, which can be general or specific. There are tools you can use to determine the level of decision making ability of your child. The supported decision making process, the ARC determination scale. Let's take a look at both. Life course tools list a charting course that has daily life and employment, healthy living, and other daily living skills that can be evaluated based on the amount of support that's needed. I can decide with no extra support. I need support with my decision, or I need someone to make this decision for me. The ARC self determination scale is a little more detailed and has several different sections that deals with independence, self regulation, as well as psychological empowerment. Some of these you may need to fill out for your child, or they may need assistance with reading some of the questions. Section 4 is self realization, and then there is the scoring chart. There are videos online that will also show you how to properly score. Now that we've determined what level of support your child needs in decision making, it's time to look at the different types of guardianships which may be best suited for your situation. The ARC of Jacksonville records under Guardianship Basics types of guardianship. Guardianship of a person. The guardianship of the person has the authority to exercise only the personal rights that have been removed from the ward by the court and delegated to the guardian. The rights that may be removed vary and are listed here and are similar to those that we referred to in the video. The guardian of the property. The guardian of the property has the authority to exercise only the rights that have been removed from the ward by the court and delegated to the guardian. However, the guardian of the property does not have the authority to sell, transfer, mortgage, or donate any of the ward's property without prior approval from the court. And then there is the guardian of the person and the property. The guardian of the person and the property has been given the responsibility by the court to make decisions regarding both personal and property rights of the ward. It will be the responsibility of the guardian of the person and property to file with the court all required initial and annual reports, which we'll talk about later. Guardian of a minor is listed here, as well as there are various types of guardians that involve public, if there is not a public guardian, when there is no one who is able to act or willing to act on behalf of the person. Again, the different types of guardianship that you should consider as you're trying to make your decision: person, property, person and property, minor, public. One we didn't talk about, which was veterans. Voluntaries, when the person can voluntarily give you their guardianship. And then there are times when emergency and temporary guardianship are available. What resources are available to obtain guardianship? flcourts.org provides resources under guardianship, and it gives you legal definitions as well as statutes and forms that must be completed if you do not have an attorney on your own. Petitions to determine incapacity, petition or order of guardianship, letters of guardianship, guardianship plans, orders for appointment, advocacy, and even inventory. Stetson Education Law also provides what's called Florida Wings, which is working interdisciplinary network of guardianship stakeholders, and it provides resources for individuals on decision making options as well as guardianship online courses. Here, exploring my decision making options, it is an amazing resource that reviews some of what we've discussed and even adds more. The supported decision making is listed, management options. It discusses power of attorney, trust, representative payee, and what we can be concerned about with healthcare surrogates, advanced directives, living wills, medical proximies, and additional guardianship advocacy, limited guardianship, plenary, which is our full guardianship, which is the same process for limited. And it's all explained here. And then it also gives you a snapshot of another shared decision making tool to best decide what level of guardianship is needed. What should be expected of the guardian? What responsibilities and reports are required to be completed by the guardian? The Florida Bar Association lets us know what a guardian does. The guardian may exercise rights that have been removed from the ward and delegated. If the court finds that the ward is partially incapacitated, it will appoint a limited guardianship to perform. So, also, is the guardian accountable? Yes, a guardian must be represented by an attorney who will serve as attorney of record. Guardians are usually required to furnish a bond and may be required to complete a court approved training. Is guardianship permanent? Guardianship does not have to be permanent. A guardian may be held accountable and removed as a guardian if the guardian fails to carry out the expected duties. And finally, there are reports required by the court. There is an initial plan for the ward, which is based on recommendations of the examining committee and must include provisions for medical, personal care, and a type of residential setting. There are annual plans which must be completed to include the current location of the ward's condition, the ward's needs, and whether there are changes expected in the coming year. And then there is an initial inventory. Within 60 days of the court issuing a letters of guardianship, there must be an initial inventory to list all known assets and property belonging to the ward. There's annual accounting, simplified annual accounting. So there are responsibilities attached when you decide to become a guardian. Hopefully, through this training, you have been given tools to help you decide and complete the process for guardianship. You should look at the level of decision making of your child, the type of guardianship needed, explore the resources that have been provided, and then prepare for the responsibilities. Thank you, and we hope that you have great success in your next portion of your life.